We have major breaking news out of the United States Supreme Court. The United States Supreme Court has requested that Arundel County, Maryland, respond to a challenge that has been brought by Maryland Shall Issue, a very powerful and important gun rights organization in Maryland. They are before the U.S. Supreme Court involving a compelled speech under the First Amendment case. We got to break this down, but it looks like the U.S. Supreme Court is extremely interested in hearing this case, and that is good news for the gun industry, the gun movement, and our Second Amendment rights. Let's talk about all of this when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed: What the 10/7 Attacks Teach Americans About the Right to Bear Arms. Check it out on Amazon. Learn a lot about the Second Amendment internationally, the right to bear arms, and its importance so we never lose our constitutional rights here in the United States, including, but not limited to, our right to keep and bear arms. All right, folks, so yes, I'm in a suit today. It was another Fox News day. I was on Maria Bartiromo's show talking all about the debate and the Constitution, Donald Trump's legal issues, and so on, but reacting to the debate. Not going to get into that here because you can watch it on TV, but yeah, that was quite something. But, you know, what can you say? Very interesting times we live in. So with that said, let's talk about another big event that's going on outside of the presidential debate issues, and that is the U.S. Supreme Court has expressed interest, real interest, in hearing a case out of Maryland. The name of the case is Maryland Shall Issue, right? That's the organization, very good group in Maryland. Maryland Shall Issue against Arundel County. Now, we covered this story a year or so ago where I discussed how Arundel County in Maryland was requiring, pursuant to county ordinances and regulations, that gun dealers in that county had to turn over and had to display and give out and make available to all their customers suicide prevention information that basically tried to suggest there's a correlation, if you will, between gun ownership, gun possession, gun access on the one hand, and suicides on the other. Now, we're going to talk a little bit about the causal effect or the lack thereof in a few minutes. As you know, under the First Amendment, you have various protections, one of which is the right to free speech, one of which is the right to a free press. Now, it is clear, black and white U.S. Supreme Court precedent that the right to free speech also includes other concomitant rights, such as the right to not speak, the right to not be compelled to speak by government to say something that you don't want to say. So the government can't come out and say, we want you to say Joe Biden is a great guy, and if you don't do it, bad things will happen to you, because that would violate the First Amendment. They're compelling speech that you may not agree with, and that is a no-no. So that is the argument that has been advanced here in this case of Maryland Shall Issue versus Arundel County, where basically they're saying that the gun dealers are saying this is BS. You know, you're making us hand out really anti-gun literature with a bunch of anti-gun rhetoric, right? And this hyperbole, and all these sort of messages that we wholeheartedly disagree with. And that is a no-go. It violates our First Amendment rights to remain silent on the question, and we don't want to hand this out. Because what you're really making us do, Arundel County, is making us hand out literature that suggests that guns are bad. And we totally oppose that view. That is not our view, and we don't want to speak to that issue. And Arundel County says you have to do it. It's the law. Do it. Surf. Right? So that's the message from Arundel County to the gun dealers in their county. So the Maryland Shall Issue, along with some dealers of firearms in the county, brought this lawsuit saying that this violated their First Amendment rights. They were being compelled to speak on a message that they did not want. They also talk about that case of Creative 303. You may remember that Supreme Court case a couple years ago. Remember, what we talked about 2 years ago will come back. It all connects up. That's why I'm trying to make you the smartest person in the room by sometimes talking about cases outside of the context of the Second Amendment. Like today, this Maryland Shall Issue case deals with the First Amendment. All of our constitutional rights work together to protect all of our liberties, all of our freedoms, and our country. That's why the Constitution in all its aspects must be respected, not just the Second Amendment, but the First Amendment and the structural Constitution itself. But I digress briefly. But we talked previously last year about the 303 creative case, which was the case, I believe, out of Colorado, where the woman turned on a web design business and she sued because she said she did not want to have to create websites that were dedicated or celebrating or discussing gay marriages. And she said that she didn't want to be forced to do that because that would be compelled speech, forcing her to articulate views as an artist that she disagreed with. And she wanted to make it clear that even though the law said she had to do it, basically, she wanted a ruling from the U.S. Supreme Court that says that is not allowed. And the U.S. Supreme Court ruled in her favor, saying, yeah, you know, that's compelled speech and you can't be forced to do so. Now, with that said, what happened in the case up to this point? The Maryland shall issue plaintiffs brought the lawsuit in federal district court, and the federal district court ruled against them, as did, of course, the terribly anti-gun United States Court of Appeals for the Fourth Circuit. You know, that's where the judges are on the Kobe case. You may remember that, and on the Bianchi case and whatnot. So that's a terrible, absolutely terrible Court of Appeals there when it comes to gun-related rights. So they affirmed the lower court decision, saying this was not a violation of the First Amendment. And what then happened was Maryland shall issue petitions for cert, and that is now up before the U.S. Supreme Court, and it's being considered for a potential cert grant. And what just happened is that the U.S. Supreme Court directed Arundel County to submit an opposition or a response to the request for cert. Now, the U.S. Supreme Court really only requests a party opposing cert to submit a brief if they're interested in the case. If they're just going to deny cert out of hand, no big deal. They don't need to hear from the other side. But here, Maryland shall issue, file their petition for cert, and then the Supreme Court looked at this and obviously said, we're curious about this case, we're interested in this case, and they just requested that the county submit an opposition or some sort of a response to the petition to see what they say. Now, what's very interesting here, and then we're going to get back a little bit on the merits of this claim and what it means under the First Amendment. I think what's kind of interesting is I took a look at the Supreme Court docket for this case. I'll put a link to it down below. And the lawyer representing Arundel County is Neil Cattell, who's an excellent, high-end, super lawyer. And what I'm about to say would not shock me, but it's being reported that his hourly rate in some cases a couple years ago was almost $2,500 an hour. Almost $2,500 an hour. That is a pretty high hourly rate for lawyers, even though a bunch of lawyers are in the thousands of dollars an hour. And, you know, that's just the reality of it, where it is. So the point being that obviously Arundel County decided to go out and hire one of the most expensive, best lawyers and law firms in the country to defend this. So they must be particularly worried about this case, or why would they hire such high-end legal help to defend their ordinance in one county, of which there are over 3,000 counties in the United States, and yet a county, Arundel County, Maryland, goes out and hires a basically $2,500 an hour attorney. Well, I wonder how all that plays out. I'll let you speculate as you see fit. But I'll put some articles about the lawyer and also about this case down below, so you can read about it yourself for further information. Anyway, with that said, let's talk about the merits of the case. Now, there's some black letter law you should be aware of. In addition to the fact that the First Amendment says that the government cannot compel you to convey a message that you don't like, there are some instances when you're dealing with commercial transactions where perhaps they can do certain things that you might not want to do. And what I mean by this is when the Supreme Court looks at free speech cases, they try to assess what kind of free speech we're talking about here. So if you're talking about political speech, that's entitled to the greatest types of protections. But when you're dealing with what's known as commercial speech, buying and selling goods and services, well, there is a little bit looser standard, and the government can be more involved with regulation and involving themselves in certain respects because they want to govern and regulate some sorts of commercial activity. So, for example, if you go into a restaurant in some states, it says that if you buy this hamburger, it's, 500 calories or whatever. That is allowed because A, it's commercial speech, and it discusses a fact, and that's key, a fact about the product. How many calories is in at that hamburger at that restaurant? So again, it's commercial speech in the context of buying or selling the hamburger, commercial activity, and of course is conveying factual information that can be understood to be true or false. That is generally acceptable under the First Amendment. Now, with that said, if the government decided that they want to force you to say something like, buying this hamburger with a bun is going to make you fat and give rise to a diagnosis of diabetes and make you depressed, well, that becomes not so much purely factual information. Now you start to get into opinions and guidance and other things, and that the constitutionality of that is much more sketchy, shall we say. So what's going on here, of course, is that they're basically telling these gun dealers that suicide prevention, and that's what this is all about. That basically they're saying that you have to make available information that encourages people to get help if they feel like they're worried about suicide, and to show a connection between suicide prevention, and firearms, and hand out this information. And the gun dealers are like, look, we disagree with all that, and it's not purely factual. A lot of that is opinions, and it's very disputed. In fact, the plaintiffs in this case, Maryland shall issue, offered up an expert, someone you may have heard of before, very famous expert, Gary Kleck, a professor, Gary Kleck. He's done a lot of work, for example, in the area of defensive gun uses, and is considered a very well-established, respectable expert, even by the anti-gun community. I think generally respects Gary Kleck, although they might not like what he says. You may recall a few years ago, there was that whole kerfluffle where Gary Kleck's work was on, I believe, on the CDC website, and basically there was an attempt to remove it from that government website by anti-gun organizations because they thought that the information about the number of defensive gun uses in America was hurting the gun control cause. So that's the same Gary Kleck. Now, the Gary Kleck in this case, offered an opinion basically saying that the connection between gun accessibility on the one hand and suicides is, shall we say, not that established, and in many respects is utterly denied that there is a connection at all. Because if you look at countries, for example, like Japan, that has no guns, you have very, very high suicide rates, much higher than the United States, and they kill themselves in all sorts of ways unrelated to guns. Obviously, there's a lot of different ways you can kill yourself. We know that. There's pills, over-medication, there's locking yourself in a garage and turning on the car, there's jumping off bridges and whatnot. There's a whole host of ways that people have been doing this all around the world long before there was even guns, and even today in countries where there's no guns. So the connection between firearm accessibility and suicide, shall we say, is not as purely factual as, let's say, there's 300 calories in that hamburger that you're going to buy or not buy at that restaurant. So this is quite interesting. The other thing to keep in mind is there's a Supreme Court case out there dealing with the pro-life movement. As you know, the pro-life movement opposes abortion, and the pro-abortion or pro-choice movement supports abortion rights. And what's going on, there was a case in California where the state of California was trying to require the pro-life crisis pregnancy centers. They were trying to encourage women who were pregnant to not abort their babies, to keep the babies and have the babies be born. That's what they were trying to do. But the state of California tried to force those pro-life pregnancy crisis centers to make available and hand out really pro-abortion materials. They went to the Supreme Court, and the Supreme Court says, yes, you cannot compel pro-life organizations in California, in their place of business, in their clinics, let's say, to hand out pro-choice, pro-abortion materials, and that is not allowed. And what the argument here is that forcing gun dealers that sell guns and gun-related accessories to hand out this sort of gun-connected to suicide prevention information, you're basically disparaging the product. You're offering opinions that you disagree with, in the same way that the pro-life movement in California was being forced to convey information that they totally disputed and disagreed with about, abortion opportunities, options, and rights, and so on. So again, what this case is before the Supreme Court is the argument by the plaintiffs, Maryland shall issue, is that they should not be forced or compelled to hand out this anti-gun literature, which is what they view as anti-gun. I think that's accurate. The suicide prevention literature. They should not be forced to do this. And they also object to the fact that their expert Gary Kleck, who offered these opinions in the case, was not allowed to testify by the trial court because they said the testimony, at least this is what the court said, the testimony of Gary Kleck was not relevant, even though the testimony of Gary Kleck established that there is no connection between gun ownership on the one hand and suicides on the other hand. So this literature that's being handed out is highly speculative and opinion driven, which is fine as a conceptual matter, but it's not fine if you're trying to say it's purely factual information about a product in connection with a commercial service or commercial activity. That is not allowed under the First Amendment. And the fact that the courts rejected Gary Kleck's testimony on the grounds that it was not relevant really is another reason why the U.S. Supreme Court should grant cert and fix this problem down there in Arundel County, Maryland. So anyway, there you have it. I'll keep you informed. We'll see what the Supreme Court does, but I do think this First Amendment case could be quite interesting, and I suspect the Supreme Court obviously is very interested in this. That's why they're requiring the lawyers for the county to submit papers in the U.S. Supreme Court over the next few days, and I will let you know what they say when they do so. So there you have it, folks. Don't forget to follow me on X at 4Boxes Diner. Make sure you subscribe to this channel, and we'll see you again soon here at the 4Boxes Diner.
Orders up. Table 2A.